Okay, I'm joined by the Attorney General of Grenada. This morning, he's joining us to essentially give us a response to some of the reactions that took place in Grenada over the weekend with respect to the coronavirus disease control bill. Mr. Eji, so you just appeared on the radio show with Shaggy this morning. You intimated that Grenadians, quote, know where to find you if they have questions about the proposed legislation. Is that how the process works, sir, with respect to public consultation?
Well, let me say this. Good morning, Mr. Bubb, and
Yes.
thank you for having me on this show. I want to begin by saying that we need to perhaps put this in context to understand how we got to where we are presently. We began our coronavirus journey here in Grenada at the end of March of this year, when a state of emergency was declared. We continue to exist under that state of emergency. And from the get-go, we were using regulations passed under the Emergency Powers Act, which allows Cabinet to take certain measures, including a curfew, and as well as all of the measures we have been taking so far. We don't have any other substantive laws in Grenada which would have allowed us to do the things that we have done, except that we had to utilize the Emergency Powers Act and Section 17 of the Constitution, which relates to declarations of a state of emergency. And having taken that step, we were, in a sense, compelled to take that step to ensure that we could put measures in place to have people not, to stop the spread of the coronavirus. From the beginning in March, there were comments being made and raised in the public domain that we should not have used regulations because regulations are subsidiary laws and they are more or less passed by the executive of a country. You know, you can have substantive laws passed by parliament, and then you have cabinet, ministers of government being authorized to pass sub-delegated legislation, rules and orders and so on, SROs. And that's the process we have been utilizing. But since we started that process, we have been listening to the feedback coming from the ground, coming from the public, coming from the stakeholders. In the very early days, persons were saying, why are you using regulations? Why don't you go to parliament? And so it was not appropriate at that time, having regard to the pressing urgency that was on Grenada, protecting the public, protecting the people of Grenada, that for us to go to parliament and debate this matter, having to go through two houses of parliament, because we needed to take action immediately. And we took that action. But since then, we have been having feedback. Mr. Bubb, we've been having feedback.
Yes.
We've been having criticisms on every aspect of the regulation. We have been listening.
But Mr. Attorney General, with respect to that question, now, as I understand it, Chapter 1, Section 17, subsection 6, already gives Parliament the right to extend any state of emergency that the Governor General would have gazetted. So my question is, why would there be a need for a completely separate bill at this stage, notwithstanding the feedback that you're indicating that you received, right? Because as I understand it, and as I read Section 17, the Governor General has the authority to extend the state of emergency. So can you intimate as to why there would be a need for an entirely new piece of legislation to substitute for that particular Section 17 of Chapter 1 of the Constitution?
Let me see if I can answer it this way. And we need to start within the context that I've been describing and get to the point of saying we have public health laws in place. We have a Quarantine Act in place, but none of these laws give us the kind of provisions nor powers to manage a coronavirus environment. And so we had to declare a state of emergency. Now, Mr. Bubb, if you look at the bill that we are proposing, that bill actually will cause us or will enable us to move away from a state of emergency. Let me make that point again. If we are able to go to Parliament and put into place measures which we want to put into place, we will not have to utilize the Emergency Powers Act. And so we can move away from a state of emergency, and it will be a state of new normalcy. It's a new normal. No, but
well, Mr. Attorney General, I'm sorry. I have to play this clip that the Prime Minister commented with respect to the state of emergency. And of course, I would allow you to answer the question, but I want you to hear a portion of this clip that I was able to capture from Grenada Broadcasting Network's To The Point program last week. Let me play that right now for you.
A fool. What we have is regulations in the state of emergency that we have to renew constantly. Will we go to Parliament with a permanent state of emergency? I mean, a law that guides us for a period of time. And I honestly believe we should have that's the process in place until you have a vaccine that protects the people from being infected. Until a vaccine is found, I don't think we should lift the emergency situation completely. The protocol should still be in place, and therefore you have to have a legal status for any such law that you implement. So that is precisely what I think we should be doing. So the present situation is we need it. Until the vaccine is found, I don't see us removing it.
Okay, Mr. Ramdhanni, no state of emergency can be permanent, right?
Well, you should not listen or hear only one part of that statement. You should not hear only one part. You can hear the Prime Minister discussing the concept of what he intends. And I started written down some of the words, what we need, and he did use the word permanent, but he then immediately followed that by this phrase, a law which guides us for a period of time. No, so you have to
those
take
two
what
things
he's
are
saying.
not mutually exclusive, is what you're suggesting.
No, what I'm saying is that when he used that phrase, a permanent state of emergency, you have to take what he said next to explain what he said before. And what he said next was a law which guided us for a period of time. That's what he said.
For a period of 6 months.
Right? We have not left the emergency completely, he also went on to say, at the very end of that. We have not left the emergency. And this is what I have said. I have said that we are in a new state of normal, right? And this new state of normal will cause us to take measures which would ordinarily only be taken in a state of emergency. But this is why we have to go to Parliament, Mr. Bubb. We have to go to Parliament.
Okay.
Because if we are passing this by regulation, we need to have that state of emergency. But we need laws which guide us for a period of time. And if we can get Parliament to sit, we will have substantive legislation which would ordinarily be dealt with under emergency regs. But now we can get Parliament to do those things. So Prime Minister must have been contemplating that we are in that new state of normal, which for all intents and purposes resemble very closely what is a state of emergency. We have, Mr. Bubb, we have a state of emergency right now. If you look at the draft bill replicates almost all of the provisions of the regulations.
No, Mr. Attorney General, I'm sorry, I don't think that's accurate. Now let's get to some...
replicates almost all.
Almost all. So let's get to some of the specific measures that it is not replicating, right?
Thank you, Mr.
And let us begin in miscellaneous part 5 in section 24. And I will quote now. It says that it shall be the duty of every police officer to enforce, in parentheses, using reasonable force if necessary, close parentheses, compliance with this act and with any order, instruction, or condition lawfully made, given or imposed by any officer or other person under the authority of this act. And for such purpose, any police officer may enter any premises without a warrant, unquote. Now, Mr. Attorney General, this particular provision sounds unconstitutional. The permission for a warrant
Hold on, Mr. Bubb.
be granted by a magistrate's court.
Hold on, Mr. Bubb.
Yes.
You started this line of conversation, and I'm smiling with you.
Yes.
To say that you were going to read me a provision which was not identical or almost identical to what was in the reg.
Yes.
Then you went on to read it and then said it's unconstitutional. So let me answer both of them,
Sure.
which you have raised.
Absolutely.
First of all, if you look at the regulations, Mr. Bubb, you will see that those exact words in a section in the regulation. Presently, the regulation which has been governing Grenada, which is presently in force, contains that very same provision. Yes? But you have gone on to a separate point. So I can't tell you that because we have put it into the regs that make it constitutional. I'm saying, look, it's identical to that one. So what we were proposing is not something that we haven't already been doing. But let's go to the second half of this conversation.
Mm-hmm.
The question of constitutionality, right? Now, if you look at the fundamental rights which are being engaged, right? What are the fundamental rights? The right to protect against arbitrary search, right? The entry into someone's home, you have a right to your personal liberty, and you have a right to protect against arbitrary search for someone to come into your home to do anything. So you're invading someone's personal space. Those fundamental rights, Mr. Bubb, are given life in our Constitution. And when it comes to liberty, for instance, yes, when it comes to liberty, you have Section 3 of the Constitution, which says this: no person shall be deprived of his personal liberty, save as may be authorized by law in any of the following cases. And the Constitution goes on to say that you can interfere with personal liberty for the purpose of preventing the spread of an infectious or contagious disease. I'm literally reading Section 3.
Section
3.
That's Section 1. Let me note that.
1G. 3.1G. I'm reading that section, which tells or gives power to Parliament to pass a law to allow the police or the executive to interfere with personal liberty for the purpose of, that's the word? Preventing the spread of an infectious
the spread of an infectious disease.
Infectious or contagious disease. Yes?
Okay.
And then it goes on here. Section 7 says this. Let's go on to this entry into premises. Yes? It says this. Except with his own consent, and I'm reading Section 7 now. No person shall be subjected to the search of his person or his property or entry by others on his premises. That's what the Fundamental Rights Protection says, Section 7. No person, except with his own consent, shall be subjected to the search of his person or his property or entry by other on his premises. But Mr. Bubb, the Constitution recognizes that none of these rights are absolute. And so it goes on by subsection 2, and it says this: nothing contained in or done under the authority of any law shall be held to be inconsistent with or in contravention of this section, to the extent that the law in question makes provision that is reasonably required in the interest of defense, public safety, public order, public morality, public health, and it goes on. And so the Constitution itself says that you can pass a law which will allow you to enter someone's premises once it is reasonably required in the interest of public safety, public order, public health. And you know, Mr. Bubb, hold on, let me finish the talk.
Yes.
Presently in Grenada, before COVID-19, we have an act called the Quarantine Act. Yes?
That would be the Quarantine Act of 1947, correct?
Yes, Mr. Bubb, you're with me. Thank you. And the Quarantine Act of 1947, which even now is constitutionally sound because of the provisions I have just read, has the exact same provision, word for word, that is contained in the regulations and that is proposed in the bill that is going to Parliament. And when you look and you read Section 7 of the Constitution, it gives power to Parliament to pass such laws, and they will remain constitutionally sound once you come to this conclusion, they are reasonably required. And the test for that, of course, ultimately gets to a court. But you and I are reasonable men. Let's examine a possible scenario. let me start from this. Why would you think that the Quarantine Act gives the power to the police force to enter people's house without a warrant? Why do you think so? It is because the environment that the Quarantine Act was created to deal with is where you have infectious disease being brought into Grenada and going to some local place and getting into the homes of people. And the lawmakers at that time conceived, and I dare suggest that you can conceive this too, that you may have situations where people are found to be infected with the coronavirus, an infectious disease, but they decide, notwithstanding that, they're going to call a coronavirus party, a COVID-19 party in their home. And people are invited into their homes. Now, hold on. You may say, well, why don't they go and get a warrant from a judge before they enter? Yes, they could go and get a warrant. Mr. Bubb, if you were asking me that, I would agree with you. I would say, I believe that every entry into a home should start with that concept of having to get a warrant, because my home, I have a home too, and I would like it to be done that way. But you could find situations where life is at risk. Imagine your child, your family member was invited to this party and they didn't tell you a word, and they're about to enter, and they have entered. And a neighbor called the police station and said, people have just gone into the house that man is put into quarantine. The police officer, what would you prefer to happen? What would a reasonable person want the response to be? Pick up the phone, call a judge who may or may not be available, who may or may not say to you, swear an affidavit, or give me more information, or go and get some officer to come and raise his hand and all of that to tell me something on Skype or Zoom. I want all of that to be done. In the meantime, more young people or people generally are entering the homes? Or would you prefer to have a power being, and I'm not, you see, this conversation has gone to policy, because
it has gone, and I know that.
I have demonstrated, I hope, that it is constitutionally permissible. The question is now whether, as a policy, lawmakers, the public, would like to see this kind of power being given to police officers. So
right, I believe
that
that is one of the concerns that Grenadian people have with respect to. There seem to be this notion of giving law enforcement and the Minister of Health, and that is something we will get to, the Minister of Health and the Chief Medical Officer sweeping powers.
Well, you know, if you look at it, the police force in Grenada already, in the common law, have powers to arrest and without a warrant anyone they see committing an offense, or if they have reasonable grounds to believe that the person has committed an offense, to arrest without a warrant, Mr. Bubb. And in fact, there's a concept known to the common law called hot pursuit. It also exists in the USA, having come from the common law based background. And hot pursuit is that if you see chasing a felon, someone escaping the scene of a crime, you're allowed to chase him into their homes. You're allowed to enter by force into the home of that person to apprehend him, because it is all part of the commission and the escape from the crime. So the common law, which is protected by our constitution, these concepts, except where they conflict, but they do not. In fact, Section 7 of the Constitution literally and expressly gives life to that power to enter a home without a warrant. It expressly does that. And so coming back to the policy decision, our constitutions are living creatures. Our constitution must continue to develop and evolve and to grow with the maturity of the society which it governs. And so I agree, Mr. Bubb, this is a very relevant discussion. But let me make the point that this conversation started because people did not say it was a wrong move to make. This conversation began because people were saying this is unconstitutional.
But not only that is unconstitutional, but again, I would go to one of the measures in the bill, another part of the legislation that some find problematic, who also raised the constitutional question, is in Section 4, which proposes to impose a penalty of 25,000 EC dollars, Mr. Attorney General, as a fixed penalty and imprisonment. Now, it
No.
doesn't say or imprisonment, right? Now, I'm not an attorney, but it says and imprisonment for 12 months. What was the rationale behind changing the penalty with respect to that monetary cost from 1,000 EC dollars to 25,000 EC dollars?
Let me put it in this context. First of all, it is quite incorrect to say that it is a fixed penalty. The structure of our laws.
I'm just reading what's in the bill.
No, let me explain what our laws say. Our criminal laws make a particular point that when you see a maximum penalty in a bill, in an act, the courts will have a discretion. All criminal lawyers know this, and I suppose many other lawyers know this, and many persons know this as well, that whenever you see a maximum in a bill, it means that that is the maximum that can be awarded. And the court will have a discretion to give you any figure from 0 to 25.
So in other words, when adjudicated in court, the magistrate can decide what would be the penalty to impose.
Yes, and the magistrate can actually decide to give you a 0 penalty and reprimand you and send you off.
Okay.
And can also decide that this is a case where instead of a penalty, I should impose imprisonment on you, or I can do the maximum on both. I can fine you 25,000, or I can fine and sentence you to 12 months imprisonment, or I can do neither, or do a lesser value of each in combination, because our criminal laws are set up that way. There's a section in the criminal code which literally says that, yes? And so all laws that come to that, and let me make the point, when the penalties were being created under the regs, the $1,000, that was the maximum penalty that the legislation, the Emergency Powers Act, gave the delegated authority to impose. In other words, the Emergency Powers Act says that if regulations are going to be made and they are broken, the maximum penalty you can impose is $1,000. Yes? That's what the Act said. So when the regulations were passed, the regulations could not increase the penalty. But there were persons in the community who were saying that, look, we have people walking around in Grenada in the early days without regard for others. And people were concerned that the penalties were too small. People were concerned that there were persons there who could easily pay $1,000 and they would continue to break the law. So what the policymakers are contemplating is that not everybody is going to be imposed at $25,000, but we must put a realistic punishment, because you could have somebody who know they have the coronavirus. I'm not saying no. And that person can decide, in my example earlier, to call a party, Mr. Bubb, and to bring people in his home and to socially interact with them and give each one of them the virus. Yes?
Or have a business place open beyond the hours of business. Go on.
That one, I'm giving you the worst case scenario.
Yes.
The worst case scenario is where someone knowingly presents himself to others with the strong probability that he will infect others. And others are indeed infected and somebody dies. That person is charged, Mr. Bubb, and you bring them to court, Mr. Bubb. Do you want the penalty, or should the penalty be, I don't know, but I'm posing it to you and your listeners and your viewers.
Yes.
Should the penalty be $1,000? In fact, you might now tell me, Mr. Ramdhanni, the Attorney General, that penalty should be really more than that for that scenario. It should really be $250,000, and perhaps they should get 5 years or 10 years in jail, or perhaps we should give them more. You might start to say that to me. Of course, if a man is walking along the road without his mask and he gets arrested, I can't see any magistrate saying, "Oh, let me imprison you for 12 months for simply doing that." That would be an offense that should be ticketed. That should be where the policeman says, "Here, I'm writing you a ticket. First offense, $500. Second offense, $750. Third offense, $1,000. Fourth time, oh my goodness, man, you're not stopping, are you? So I'm going to arrest you now. And I'm taking you to the magistrate. The magistrate hears the case and says, well, 500, 750, and 1,000 didn't deter you, man. I'm going to impose a $5,000 on you." He comes back again. Magistrate says, you're not really learning with this monetary fine. And this is how our courts behave. This is how law everywhere in the world, in America, everywhere in the world, it operates in this manner. A magistrate might decide, you know what, for you to learn, for a lesson to be taught to you, you perhaps need to go and spend 3 months in prison. And so he gets a 3 months. And so that is the flexibility that is inserted in the act. It contemplates various scenarios. This is what crafting and drafting laws and making up policy it has to be considering. When you're developing laws, you don't only cater for the errant person who is going to run out of his home and go to the next door for a pint of milk, and you say you're going to charge them. And if you realize, Mr. Bubb, the police have been really operating on a mature basis in this environment. How many persons have you heard have been arrested for not wearing masks? I suspect you may not have heard of any. I mean, some persons have gotten tickets, yes, but the police have been approaching law enforcement in this manner, having regard to where we are in a sensible manner. We hope that the citizens of the country, the people in Grenada living here, will be responsible in the way they carry on themselves. But you and I know, Mr. Bubb, sometimes you have to have meaningful laws in terms of penalties. I'm talking about. I'm on that conversation. You have to have meaningful laws that make a difference, that deter persons from performing those actions which society has decided you should not carry on. Meaningful laws. And, section that says 25,000 and 12 months, I expect to hear vigorous debate on those sections in Parliament and the Senate, because it's possible, as you put it, that they might want to consider it's too high, or they might consider it's too low. Maybe these further consultations might lead us all to realize, on that scenario I just presented, that you might want to up the penalties.
Okay, I have two final questions because I know that you have to run to cabinet.
Hold on, Mr. Bubb. Only two final questions. We can.
Oh, we can continue to engage. That's great.
Well, I'll tell you when I'm supposed to be already there, but I've been given a little bit time. To address this matter. This is very important.
Yes, absolutely. Now, the bill, as I indicated before, it seems to give sweeping powers to the Ministry of Health and the Chief Medical Officer, as opposed to the cabinet. Now, in the 1984 legislation and in the current Emergency Powers Act, that authority belongs to the cabinet. Are we going to be seeing a situation where those powers are shifted from the cabinet and given to the specific domain of the Chief Medical Officer in the Ministry of Health? And why this change?
Let me remind our listeners today, or say this to them. We start from a concept under our Constitution. There is a concept which is known as collective government. Anytime any law says that certain ministers will exercise power, and the chief medical officer will have to act in accordance with the policies of his minister. Yes? Anytime we say that, it means that not only that minister is acting, but it is the entire collective will of cabinet. So the formulation, even though you are seeing words that are looking different to you, the formulation remains the same, where the delegated power that is going to be exercised here, it's going to be exercised in accordance with the collective will of cabinet. So even though you're seeing, and one of the reasons, to your viewers, I think this was an important question. One of the reasons we are seeing the insertion of the chief medical officer literally being named here is fundamental to the management of this process. Because I have also heard questions when we were drafting this and we were looking at the policy issues, it was a question of how much power should you give the police officer? And you would realize that almost always when the police are exercising powers under this act, they are doing so under the direction of the public health officers, the persons who are really going to be the ones who are measuring the risk that are out there, who will make determinations as to who should be placed in quarantine, who should be contact traced, who should be required to submit themselves to a test. Yes? And so whenever it comes to medical questions, whenever it comes to isolation and people being screened and tested, all these medical test questions, it begins with the Ministry of Health, the Chief Medical Officer, but it ultimately comes from the cabinet's direction on these matters. But the cabinet direction will have to be guided by the medical information. And this is why you don't want necessarily the executive making these decisions in law without any recognition of the guidance being provided by the medical personnel within the executive structure. And so the Ministry of Health has to be involved. The chief medical officer, we expect that he will exercise these powers and his guidance and his recommendations when he's going to issue directions, that these are all done on a medical basis, that there is medical justification as to why these decisions are being taken. And this is why you see that mechanism being created in such a way that the medical team, the chief medical officer of this country, must be involved in this process, guiding this process, because these are a lot of medical issues we're dealing with, but they have that law enforcement component. And so these arms or these components of the government, of the governance structure of government, must work in tandem, and they must work in an informed manner to carry out the protective mechanisms and measures that are necessary.
Okay, okay. All right, Mr. AG, I have another question unrelated to this particular bill. And that has to do with, now, actually, before I get to that, the bill was withdrawn from parliamentary consideration on Wednesday. What happens now? And when would that bill be brought back to Parliament for consideration?
Let me say this. I think I began to address this when we started about why have we sort of pulled back from, and I was attempting to say it then. I don't know if I had finished it, you will tell me, that we were engaged in a discussion and listening to the feedback over this 4-month period. We have literally seen as many comments, and when you look at the bill compared to what the regs are, you will see we haven't shifted the goalposts except to relax and ease up some measures. Yes, and so we already have gotten a lot of comments on this.
Did you get any comments from the Grenada Bar Association, because they're saying they were not consulted?
Well, consulted. Let me agree with them that they were not consulted in the traditional sense. But the bar has been constantly providing me through various members, calling me, talking to me, writing in the newspapers. I've seen these things. I have discussion with some of them. And so I agree with them that there was not a formal consultation process. I think, having regard to how this has played out, that this consultation process is necessary.
So do you regret not consulting them as an official body as opposed to consulting individual members?
Well, let me put it this way. I would have thought that if everyone had sat down and analyzed this bill, really, they would have seen that the bill was effectively reflecting the regulations. And so there should not have been this outcry, Mr. Bubb, put it that way. And this outcry has caused some level of anxiety. That is what I regret. I regret the anxiety that has been caused. And looking back at it, on further reflection, I would agree that this anxiety should have been avoided. And so I am pleased now to be in this discussion with the bar, to be able to listen some more to them. Yes, because sometimes people need to simply have an opportunity to speak, to get that sense of calmness, to get past the moments of anxiety. Because, you know, it's something I said on earlier programs today, that these statements that the government is interfering with your fundamental rights and they're breaching the constitutions are very provocative statements.
Inflammatory, if you will.
Inflammatory. And when you say them, it's easy to start a narrative. It takes on a life of its own. And so,
but you can understand why people are concerned.
I understand that, you know, we've all gone through a trying time. You are not in Grenada, but you are equally in a trying time where you are.
Equally right here. Yes.
Perhaps because of, I believe you sit in Brooklyn?
Washington, D.C.
Sorry, forgive me.
But the reality is the same. The reality is the same.
Yes, so we share that level of anxiety that we have been having throughout this period. This period has been wearying on us. We're all sacrificing our peace of mind, our ability to socially interact with others. Man is a social animal, and we need society to survive. And so, Mr. Bubb, anything that calms us and gets us back to normal should really be considered. And I'm very pleased that the government have listened. We have listened, and we have provided a greater opportunity for consultation. I say greater. I hope my colleagues will forgive me. We have been listening all along, but we have not engaged in a formal consultation process. I know this is a point that has to be addressed. I am grateful to be engaged in this, and it is something affecting rights, and we should be participating in this process. So I'm pleased that we are. I regret the anxiety that has been caused.
And finally, Mr. Attorney General, and this is unrelated to this particular bill, as I said earlier, but residents of Corinth and St. David's have been protesting loss of access to parts of their beach in that community that now hosts the Grenada Marina facility. Now, how do you plan on ensuring that the Canadian Banknote, the company that is currently doing construction work in that community, that they comply with the constitutionally guaranteed right of citizens to have access to their beaches?
Mr. Bubb, I am not aware of all of the details, but I can assure you that the rights of Grenadians are we very concerned about protecting rights in this country. Our track record is there to speak for these matters. And we have listened to many of these, all of these kind of statements being made of access to beach. And we have addressed them in the past, and we will continue to address them. And this is a matter which will get the attention of the government, and we will address them. I don't, as I say, know all the specific details of this matter right now, but it is something that I will look to after this interview.
Absolutely, and I will be following up with you to see what you found out.
Yes, we can have a discussion, and I'm glad to be here today to speak of the coronavirus bill. Yes. Would be glad to again engage with you on other aspects of this bill, because there's a number of comments.
There are a number of things. As a matter of fact, I would actually want to publicly invite you back on Sunday, so that we can have a public discussion, public education, if you will, on this, so that again, as part of the process of expanding people's understanding.
Right. Let me check to see what my commitments are.
Sunday at 11. Yes.
I will confirm with you long before Sunday.
Absolutely.
Whether I'm coming on or not. I would like to be engaged some more on these discussions. In fact, I believe tonight I will be on Beyond the Headlines with some other members of the bar, and hopefully we will have a discussion which will inure to the benefit of the Grenadians and everyone who is interested in these issues and have a stake. I want to thank you, Mr. Bubb. I think we've come to the end.
Yes, we have come to the end.
I want to thank you for having me on this morning. I know we tried to link up yesterday, but we were unsuccessful. I want to use this platform to continue to assure all Grenadians that I'm interested in listening. I'm interested in continuing this discussion, but I ask that you all continue to play your own little role in protecting yourself, your environment, your family, and loved ones. We all have a responsibility to ensure we take all those steps to continue this fight to make sure that Grenada is not affected by the coronavirus. We are affected indirectly because commerce and economic activities have been severely affected, but we don't have any cases as far as we are aware in the country. And we are all to be commended for that. The population has done quite well in managing this period. There are moments when you can see the anxiety being played out when we have gatherings at beaches. You mentioned beaches earlier. We have had some big gatherings and people were not wearing masks. I want to call on everyone, please wear the mask, please physically distance. Let us protect our sisters and our brothers, our children, our parents, or our grandparents, or all our relatives and the community at large. Let us take these steps. Let us be conscious. Mr. Bubb, if not anything that this conversation has brought about this bill, this anxiety that has been created about this bill, that government is attempting to breach fundamental rights, it has given us another opportunity, another platform for us to be able to remind persons that we are not out of the woods yet. We may be a bit weary, but we have to continue to struggle and battle and protect ourselves. So let us do that. And I thank you very much for this opportunity.
All right. On that note, Mr. AG, thank you so much for agreeing to appear today. And I look forward to getting a confirmation from you for next week.
Thank you, Mr. Bubb.
Thank you. Have a good day.
Have a good day.